good afternoon, guys. This is Sandy. My name is Sanandan Sudhir, and that's Tarun Khurana. So how many participants do we have already, Anshu?
47.
47. Okay, brilliant. So I guess we're not going to wait for any more time, as we have a lot to share. I'm just going to share my screen to give an introduction to both of us. So just to give you guys an overview, I have just 4 slides here. These are long format slides, and we will continue from left to right as a process. And so there we begin. So I'm introducing Tarun. Tarun is co-founder of Khurana and Khurana. He has a lot of accolades with him, but he's, to sum it up, an MBA from IIM Lucknow. He's pursuing his PhD. He's also master's from BITS Pilani. And the company that he runs, he has a patent portfolio that he manages, which is approximately 15,000 patents, approximately 20,000 trademarks and registrations, design registrations is something that he manages. He has 200 plus employees across the world and 10 offices in India and 7 offices abroad. I think that's a great achievement from an IP firm's perspective being in India. They also cater to a lot of international customers. As far as I am concerned, I started Invent India along with my wife, Jyoti, I think about 9 years back. I'm an engineer from NIT Jamshedpur and a product designer from NID. I also founded the Indian Inventors Association. I have personally about 54 patents that are filed, and out of them 13 are granted, the rest are in the provisional state. We have about 50 plus employees as a part of Invent India. We've finished about 100 plus projects, about 20 products we manufacture for our customers, and we have about 100 plus international partners who help us manufacture these products and so on. Okay, so today's topic is basically the overall process from idea to market, idea to launch a product in the market. And these are all the steps that you would see typically. I will take you through this whole journey as we move along. And the whole idea is to understand that on each of these steps, there is a possibility that what you are doing, somebody else may be doing already, somebody else might have done already in the past. And you have to ensure that what you're doing to be unique, to create a great company, you take care of all the intellectual property related issues. So we'll go through the process step by step, and along with that, understand what all needs to be addressed. So if you look at the screen, starting from the idea, you incorporate a company, then you do some initial research for your idea, you file a patent, sometimes you don't. You then get into the product design stage, you do engineering, you do prototyping, you get the tooling done, and then you get the manufacturing done, or you set up your own factory to do the manufacturing. And along with this, at some point of time, you will also develop the need of, oh, I need a logo for my company. Oh, I need a word mark. I need a product name. I need a product logo as well. So then you have to focus on that. And for some people, it starts right in the beginning. For some people, it is like when half of the product development is done, that's when they start, oh, now I need to actually start registering my company and do everything and so on. So then you have also an opportunity to do the UI UX in case you're just doing an app. Even if you're doing a product that has an application attached to it, then you have the UI UX and the software associated with that.
Sanandan, I'm sorry. Are you sharing the presentation?
Yes, I am.
No, we can't see it.
I'm sorry, just a second. Let me know if you're able to see the presentation now.
Yes, now.
Yes, now it's visible.
Oh, I'm sorry. How do I make this go away? Okay. So I will start again from the screen. So I just spoke about myself and Tarun, and this is the key screen that I was just discussing with you guys. So basically, starting from the idea, company incorporation, research, innovation, product design, engineering, prototyping, tooling, manufacturing, and then in communication design, UI, UX, product packaging, photography, animation, digital marketing, crowdfunding, and eventually launch the product in the market. So if you actually look at all these steps, you see these red dots here. Each and every red dot means that at this point of time, you need to look at the whole legal process in some way. Sometimes it is intellectual property, sometimes it's an NDA, sometimes you have to sign a contract. And all these things generally we miss when we start a company and we don't care and we just develop a product and so on. So the whole idea of today's talk is to ensure that we understand the overall process. First of all the steps that are necessary in product development from an idea to the launch of the product. And while we are going through the steps, we are cognizant of the fact that at each point, we need to protect ourselves. Otherwise, at some point of time, somebody can copy that product, somebody can take your logo away, or somebody can stop you from doing what you're doing just because they have either done it before, or they filed for protection before, or you just don't have the right contracts with the right people. So, they are making your product and selling it because you didn't sign the right contract. You shared some ideas and you didn't sign the NDA. And so suddenly you are again in a position where they are sharing your ideas and you can't do anything about it. So if you look at the first red dot, at the idea level, you can file a provisional patent. At the company incorporation level, we'll talk about this in a separate discussion, I guess, but there is a lot of documentation that needs to be done, and there'll be a different group and discussion for that. Then it comes to design research, which means also the intellectual property research, which means you have the idea and the idea needs to be validated if that idea actually makes sense or not, both from the perspective of marketing and from the perspective of if somebody else has already done that idea in the same format or not. And then you have the strategy that you have to define. So you need to understand the patent landscape. At product design level, you have to check infringement, design infringement, product infringement. Again, at engineering level, technology that you're using it in a particular way, you have to again check infringement. When you're doing prototyping, you have to make sure that you have an NDA and a contract with the people whom you're using for prototyping. And it may be important that before you get into prototyping, you have a provisional patent filed and you have some kind of protection for your idea, because now the information is going out of your office. Then when you get into tooling, again, NDAs, contracts, again, manufacturing NDAs, contracts. Again, in the parallel stream, when you're looking at communication design, which is when you are looking at your logo, wordmark, trademark, company name, product logo, and so on, all that needs to be registered. If you are having a good user interface, and if there's a software that has something unique about it, then at that point of time, you need to file utility patents for that. If you have a Fundu product packaging, that's very different. You can do a design registration for that. Your photographs, your renderings, your animations, all that can be copyrighted. And Tarun will talk a little bit more about that. And then eventually, when you launch your product, again, you have to ensure that your brand, your product is registered all across in all the geographies. And we would be touching base on all these points as we move forward. So Tarun, to begin with, I think NDA is a very important thing. Anybody who comes to us as a consulting firm, the first thing that he does is, sign an NDA, only after that I'm going to share my idea with you. And we all end up signing an NDA. And sometimes we sign an NDA, which is more like just a normal NDA, which is on just a piece of paper. And it is signed and signatured, but it's not on any legal document, so to say. And then some of our customers, they kind of ask us to have this on a stamp paper. So can you, to begin with, help us understand the difference between the two? How it helps, what is protected, what is not, and what should we do ideally?
So, I mean, from an enforceability standpoint, thank you, first of all, Sandy. Thank you, ADI, for the opportunity. A pleasure to speak here, and very, very glad to be a part of the community. And to answer the question, from an enforceability standpoint, by virtue of any NDA, which is a commercial contract between two entities, even if it is not on a stamp paper, be it a judicial, non-judicial, it doesn't matter. It's clearly enforceable. Both the parties have willingly executed the document. The enforceability becomes a little easier because when you do it on a stamp paper, there is a notarization that gets done where there is a notary involved who will basically notarize that both the parties were in front of him. And therefore, in the absence of such a stamp paper or execution on this without some stamp duty, if one of the party contests that I did not sign it, for example, or the signatures have been fraudulently obtained, it becomes a challenge for the other party to prove that no, it was validly obtained and there was mutual consent, which again could be a case in 1 in 100 where there such a dispute may arise.
Okay, can you expand a little bit on, people expecting to sign every damn page and, a stamp on that page and then company stamp, and how much all that matters, both people signing on both the sheets, and then the number of sheets, and somebody may say, okay, you added one more sheet. How does that work?
So again, all of these are steps that have evolved over a period of time. Where when there was only a last page signature, then there were a few litigations that happened way back in 80s and 90s where there was a clear intent from one of the parties that had actually created a fraud by affixing or taking signatures only on the last page and using that signature page essentially on multiple documents. So to avoid such an event from happening is the reason why a lot of parties started insisting that all the pages have to be signed up. All of these are precautionary measures. You see, because when you're doing an NDA, a few of the NDA formats have a first party and a second party. And then the whole agreement is about parties. It doesn't really say that the first party is disclosing something to the second party. Now, there also is a big concern there, because if the whole agreement is about parties, then both of them are equal in the sense of the kind of data that they're exchanging. But if the agreement is very clear that, okay, here is this one company XYZ, which is going to disclose all the information to the vendor, ABC, then it has to be that the disclosing entity is XYZ and the receiving party is ABC. Otherwise, you are trying to bring both the parties at the same platform, which should not be the case. So the wording of the NDA, therefore, seems to be a formal mandate where every company has almost the same NDA and they get executed left, right, and center. But enforceability becomes difficult if there is a dispute, because then the other party says, okay, prove that you had given me this information, prove that I was the recipient of this information, and in fact, I was the one who had conceived it and given it to you. But if the NDA clearly indicates that I am the disclosing party, you are the receiving party, then the receiving party can never make that allegation.
So that's another important point. Once an NDA is signed, people think that whatever they are discussing is all under the NDA. So can you expand on that also a little bit? So verbally, my communication, is that under an NDA? Written text shared with confidentiality as written or not written? What does it mean after I sign the NDA? What does it mean to me in terms of my shared information?
So when these matters go to the court looks at the intent of the whole mandate. They look at if you're talking about certain communication that happened on WhatsApp or on email, but even if it did not really mention that this is confidential, but if it was pertaining to a particular mandate for which that NDA was executed, or if it in particular it is a continuation of a project that we've already started under an NDA and there was certain communication that happened on that project, I am not obligated to, for every communication, write the word confidential or communicate only by email. But certain NDAs again say that, okay, no, your only communication in writing would be the ones that will be protected, and which is again an important mandate to take care of for disclosures. Because for entities or parties that are disclosing, verbal disclosure will become very difficult for them to prove tomorrow that they were that it was really disclosed, because there's absolutely no recording unless you have a recording to that effect, which again will be a subject matter of evidence research and credibility of that evidence of how it was procured and managed. So in an ideal atmosphere, have a proper NDA executed on a stamp paper, executed on all pages. Every communication should ideally be in a single communication email chain, and only on emails. WhatsApp and other loose platforms should ideally be avoided to the extent possible.
Thanks, Tarun. That's very valuable input. The whole point is that we need to follow the process, and Tarun is the right man. In case you want to tighten your NDA when you're doing any serious communication, you can connect with him or any other lawyer for that matter. I am moving further to the overall detailed process. So, we discussed that we have an idea. So, Tarun, can you please help us with a broad idea around the patentability search and why it is important when somebody actually has an idea before he starts investing any time, money, and effort into taking that idea forward. And guys, I'm saying this because we've had customers who have come to us. We have designed their product. We have manufactured their product. They have gone to a show in Germany and they have put up their stall. And then after 2 days, they've been thrown out of that place because whatever they created was infringing somebody else's intellectual property. This was not intentional, but the point is that the process, the rigor in terms of trying to understand whether that made sense was not followed. So, Tarun.
So, I mean, patent is a long drawn process, first of all, and any company which is product oriented, be it on the software side or a tangible product, which will be sold in a retail center, for example, every company, at least heart and heart out, has an intent of developing something which is unique or differentiated from what is out there in the market. And the only way to protect once you've developed the product from anybody else copying it at a functional level, at a technical, scientific, functional level, so that they don't make exactly the same product, is essentially a patent. Because the patents, what would give you a functional protection over the invention that you have done, be it an incremental improvement or something very fundamental that you might have done. And by virtue of a patent being a long drawn process, where in countries like India, unless you're a startup which is recognized by the DIPP and you can file an expedited examination and get the patent granted in, say, less than a year, regular entities take about 2 to 4 years to get a patent granted. And by virtue of that long being the drawn process, if at the end of 4 years you come to know that because of a particular prior art or some document which was published in the public domain before the date of filing of my application, my patent's been denied or my application has been refused, what a waste of time and energy. And therefore, the whole purpose of a patentability search is to at the very beginning itself, once you've conceived an improvement or a product, get a fundamental search done to understand whether there's something out there which is already talking about it. Because if it is, I maybe take a license, maybe I try to design around even further. So your research will change, your design development will change. So patent obviously would get amended and revised accordingly, but even that may even lead to fundamental changes in the design itself of the product.
Sure. So, so guys, we do some of the patentability search ourselves. All of us, anybody who has a new idea, they just go to Google Patents and search if you have found anything. So, but what happens is that the process that we typically follow is like, okay, you'll look at 4, 5 pages, 10 pages, and then you will stop. So that's not the right way of doing patentability search, because you stopped at page number 10 and maybe the idea that you're talking about is on page number 11. So when you're talking about patent attorneys, they have some special tools which allow them to pull in the whole database across the world from all different countries, different languages, and put it together in front of their eyes in a very short span of time with the right keywords. So Tarun, can you please elaborate a little bit on the keywords and how important it is? Because we have a lot of people who come, I did search with these 2 keywords and there is nothing that is available. And so how patents are filed with different keywords, how they put the names in a way where it's not easily searchable, and then later you may be in trouble.
So there are many tools, and I don't think tools are so important. I'm not a big believer. Obviously, they help because Google Patents, for example, will only cover US, Europe, China, Japan, Korea, for example, but will not cover Latin American countries, for example. Most of Africa will not be covered. Most of GCC or even Southeast Asia will not be covered as regards the database is concerned. So free databases obviously have a downside on the coverage. But that's only one. The bigger disadvantage is that they would only allow you to do keyword searches. They would not allow, for example, us to do classification searches, where for every patent there are multiple classes and subclasses. Like for trademarks, we have 45 classes. Electronics will come in one class and my papers will come in another class. Similarly, for patents, there are tons of classes, and then there are subclasses, and then there are subclasses, and then there are international classifications, there are US classifications. So by virtue of a combination of keywords plus classification, we are able to really filter down and get a very strong set of most relevant patents, which otherwise, in a database of 1,000 patents will easily get lost, because, patents is a pretty boring stuff to read. and it's not easy it's a techno-legal document. Not everybody likes to read any which ways these days. And therefore, reading a legal document becomes all the more the hassle. Plus, somebody is calling a shaft a longitudinal member, or somebody calls it some sort of an elongated object. So there are so many variations of a particular term that unless you are really into the game and you do it on a daily basis, it's hard, because most of the inventors would do a search using keywords that they would describe their application in. But another inventor in another country will have a completely different nomenclature for his invention. So unless you have a good classification system to search on, the classification is the same. So anybody in automotive making hydraulic engines, and within that a particular subclass, will always have the same class. So classification search, different types of keywords, all of those are things that help you refine the search and the quality thereof better.
So yeah, so you're basically talking about CPC codes and all. So guys, so the whole point is that though we can do our research ourselves, but it is ideal to use a patent attorney to do the research, initial patentability search for your idea before you make it a startup or before you take it for funding and so on, because the more the time you spend before you're doing that activity, the more you're going to lose in terms of time and money eventually, and a part of your life, if somebody has already done it. And the reason is that somebody can tomorrow come and stop you from taking that idea forward. Today on the internet, in the Google, you can just type a few keywords and you'll find all products. So everybody in the world will know if you have launched something, and that's the only way. I mean, social media is something where anything that you do needs to come eventually. So Tarun, can you give us some idea about the cost if somebody is just having a preliminary idea and he just wants to do a provisional patent, not the final application? So I would like you to explain the provisional application and the final application, and also what is the cost pertaining to an initial patentability search, and then the whole process of filing a provisional application.
So at the beginning, there are usually two types of studies that are done. One is like a prior art study, where you are trying to be very expansive in nature. You try to understand what's out there in the market, what kind of technologies. So you have the problem that you intend to solve, but you want to understand what kind of solutions are available, how good are they, how bad are they, so that you can relatively position your inventive concept or your product around it. So that's a larger study of a prior art, which could cost you anywhere between 1 lakh to 3 lakh rupees, depending on how dense the area is. If you're, for example, in the IoT space, tens of thousands of patent applications flying around in the US in that space. But if you're in the space of making a semiconductor chip using graphene with one kind of coating on it, the density comes much lower. And therefore, the bigger your problem statement, the bigger your area of focus in the research, obviously higher are the high number of patents that you'll have to go through. And it's not just the patents, it's also non-patent literature, white papers and stuff like that. So that's the prior art search costs 1 to 3, depending on the area. Patentability searches are very specific, because there we expect the clients to give us the exact inventive step, what they've invented and what their core invention will be. So that costs around 15,000-20,000 rupees for us to get it done in about 3 to 4 days. Provisional takes about a week for us to draft, and typically costs around 35,000 to 50,000 rupees. Sometimes lesser, depending again on the complexity of the invention. Sometimes even lesser, maybe even 25,000 rupees if the clients come back to us with a very good draft. So if their invention disclosure itself is as good as a provisional application, we can really limit the cost and also the time that will go into it. But because the inventors write it usually in a loose manner, in a manner which would be easy for some customer to understand, but it's not obviously legal and not technically strong enough, so we have to invest time. So provisional costs around, again, 25 to 50, I would say 35 to 50 or so. And then the complete application is also around, if you were to directly draft a complete, around 50 to 70K for a complete application from scratch. There is also, obviously, when we file a provisional, we get 12 months to file a complete. So the differential amount is always the same, around 25 to 30,000 for the difference. And in India, the whole process takes about, as I said, 1.5 years to 2, maybe 3, depending on when you apply for the examination request. And then the whole cost is around about 1.5 lakh as regards the attorney fees is concerned. And the official fees, the government fees, depends on whether you're filing in the name of a company or an individual capacity.
Okay. Okay, so guys, so in the process now, now that you have a provisional patent filed, you have your digital signatures that you got for your directors, you registered your company, you got your DIN, and you have figured out a business structure. So let's say your idea is secure, and now you're looking at how am I structuring the business around it. So Tarun, can you throw us some idea if a business process can be patented, or that was something of the past, or what is the status today?
So business patents have always been hard to patent in any country for that matter. It was believed in the US that it was easier, but over the years, ever since the Alice litigation in 2007-8 and multiple litigations that happened post that, become very, very difficult. So now it has almost become a norm that whatever you try to get a patent granted for has to have a technical impact. So you have to show the technical character of that invention. So even if it's an app per se, like a Fitbit, but you'll have to basically try and talk about the sensors that you've used, what algorithm have you incorporated to evaluate the number of steps that I've walked. But if Make My Trip Tomorrow tries to file a patent, they can absolutely try to file a patent for most optimally finding out the most optimal flight for you when you're going from X to V. But that is going to be a technical way of doing it, so they'll have to say that, okay, they send out the request and then it has a binary tree structure, they navigate the nodes in a particular way, and then they sort of have a neural architecture by virtue of which they understand what is the preference of the customers, and you'll have to be very deep into it. It cannot just be based on an input and then you have 5 parameters on the basis of which you process the input and you get an output. So gone are the days when it's very easy to get a easy process, a business method or a business process patent. Obviously not in India by virtue of Section 3K of the Patents Act, but even in the US, it's becoming very hard unless you correlate, as I said, to a technical implementation. And that implementation is what you're going to get a patent for, not the business flow as a whole.
Right. So, so which means just a business idea in today's date cannot be patented, or even if you file for a patent, it is less meaningful. So until and unless there is some real technical innovation, which is first time in the world, there is no point of filing a patent. Okay, so we have filed the provisional, we have a business idea, we have a business plan, and now we are looking at choosing a business name. So here, to me, there are 3-4 key things. One is you can look for a company name. So we need to understand, Tarun, what all you can do and cannot do as far as your company names are concerned. Then you have a product name also. They may be same, but they may be different. So what do you do for the product name? And then you have trademarks and logo types and so on. So this whole space of company name, product name, logo type for both. What should you product? Should you do it all? When should you do it? What you should do? And corresponding, what are the costs? It'd be great if you can just throw some light.
So typically the process is a little different where trademarks ideally should get filed along with the company incorporation, and the patent, the provisional application should ideally get filed in the name of the company in an ideal atmosphere. You can also get it filed in individual capacity if you're in a hurry. But obviously by virtue of the valuation parameters of the entity, the investors do like to see that the IP is with the company. So if you were to go with the flow, you would obviously incorporate the entity, file the trademarks then and there itself, and then file for the utility application. But again, if the idea is more important, you can always assign it after having filed it in the name of individual capacity later to a company's name as well. Coming to trademarks for a minute, a lot of companies have products which are mapping to the company name. Now, XYZ, and the product's name that they're going to commercialize is also XYZ. So in that case, it's imperative that we file for a trademark almost around the same time as the company incorporation. So that there is no iota of a possibility where there's a lot of unscrupulous activity that goes on, where there are entities in India which whose main business plan is to essentially have a look at companies getting incorporated on MCA on a daily basis and understanding that, okay, this guy is going to sell a product tomorrow in this particular brand name, so let me file for a trademark so that when he files for it, he will not get it and he may have to then buy it from me. So the timing becomes a very important atmosphere. There are a lot of companies like Ola, for example, whose company name is not Ola, right? I mean, they're ANI Technologies, or Flipkart is not Flipkart. The company's name is something else. So the company name in a lot of cases is not the same as the brand name, but in a number of cases, they are the same as well. So they are rendering products, or they're selling products or making products by the same name. So if your company name is not the same as your brand name that you're eventually going to use for selling product, then there is not as much of an urgency to file a trademark. But if your names are same, then it's imperative that both go hand in hand and you do it at the same time. And we've had numerous occasions. There are certain companies that have a very aggressive manner of protection of their brand, where they just don't let anybody else come in. Atlas, for example, even if tomorrow somebody files for a trademark for a shoe by the name of Atlas, or a calendar, or any other equipment, Atlas will just go behind them even if they don't manufacture that product. Same is the case with another client of ours called Hawkins. Anybody in any space, in any product category, if they start using it, they will absolutely find an opposition and go very aggressive there. And then there are certain entities that, for example, over a period of time haven't been as aggressive, and by virtue of that, they've lost the whole essence. Xerox, for example, for a long time was not aggressive and therefore became a generic brand name. Haveli is a very good example, where Haveli is a very prominent restaurant, resort restaurant, whatever you call it, on the Chandigarh highway. And then when they initially filed it, obviously for reasons best known to them, things were filed differently. So there was an Amritsar Haveli, they did not do anything. There was a Punjabi Haveli that came in, they didn't do anything about it. And now when you go from Delhi to Chandigarh, you will at least see 10 different Havelis. And then one Haveli is actually just in front of the main Haveli. So it's always very funny when I see two brand names completely in front of it. So there's Mannat Haveli on one side and then the actual Haveli on the other side. And the Haveli just can't do, because there's just so many Havelis which are registered now that the whole essence has gone by of protecting it. So I think the timing of protection is extremely important. How you protect it, how aggressive you are. All of these are cost-intensive activities, correct? But I mean, unless you accommodate and accumulate some budget to these matters, you will always have some company coming in, particularly if you're in the B2C space. You'll have companies coming and selling the same product or similar products by, at Amazon and Flipkart, because it's very easy. You could keep an inventory at a house and start selling it. And then that is how the business goes. And there are tons of such examples. Coming to how you can file for a trademark, it's a fairly simple activity. You have to give the products for which you want to use the trademark, the services or the products, depending on which the classes are determined. You select the name, who will then be the applicant, who will be what is the address of the applicant. And if you've already been using it for some time, then you have to mention that you've been using it and give an affidavit associated to it. So it's a one-day affair. The government fees is 9,000, and typically the fees of filing is around 3,000 to 5,000. Again, depending on which firms do you work with.
So guys, to save time, we're just moving to the next question. There's a lot of information here, and I will share these documents. So when the recording would be shared, you can have access to these links that can help you find these things. And some of the costing structure that Tarun is talking about is also written in these documents at the bottom. And we'll populate that properly and then share with you. Here, if you see, these are all the different classes under which you have to register. So Tarun, can you please expand a little bit on, having a logo or a brand name to be registered under multiple classes, because you're selling different things and it's not just okay to just do it in one. Can you elaborate a little bit on that?
So first of all, you actually get protection for what you file. That's very important to understand, because a lot of companies, for example, if I look at the logo behind Sandy, which is ADI, and then there's a line, and then there's AMD written below it. Now, if you essentially just file for this exact representation as a trademark, what you will get a protection for is exactly what you have filed for. You don't get a protection for bits and pieces of it, which means that tomorrow if somebody starts using ADI separately, and you will not be able to do anything. AMD separately would have no existence. Again, ADI, AMD without the red color background, will have no basic meaning to it. So the most important trademark to file is always a word mark. And any logo associated with it, any graphical representation, italics, yellow color, all of that is secondary. You always get that secondary. But sometimes, you're using a mark which is a very generic mark. Now, for example, safe water, or not Bisleri, but any other regular water bottles that you use. Or you have a company in the US called Square, for example, in San Francisco. Right? So Square is a very prominent name, very common name. And therefore, for you to create an identity, you sacrifice. You say that, okay, I'm not going to stop, or I will not be able to stop anybody else from using Square as a word. And therefore, I don't mind getting a protection with Square written in red. And that's how you develop an identity. But typically, if it's a unique mark that you've developed, then a word mark becomes very critical. That's the most important. And then you gradually go up. And Flipkart, for example, has 300 applications, 300 marks. So Flipkart and then F with the Flipkart with the logo behind it, the yellow color. So every possible combination, they are protected. And as regards to the class is concerned, typically you start with the key classes. Now, if you've made a software app or something, then you'll be in class 9 and 42. But you would then ask if 1 to 35 is essentially for products, 1 to 34 rather as for products, then why am I going for class 42, for example? Now, your product could essentially be a software as a service, or it could lead to a service, or it could essentially lead that if you've only filed it in class 9, somebody could tomorrow file it in class 42 and then try to sell services around the same name. So certain classes go hand in hand, like 9 and 42. Your fashion designers would go in 2 different classes, again, services and consulting, for example. But classes, that is how you select classes, and then you mainly protect the key classes because the government fees is 9,000 rupees per mark per class. And therefore, as you grow and as your budgets can increase, you try and protect it in multiple classes.
Right. And so from that perspective, if you look at the screen, there are some trademarks and some logos in different types, like certification marks, service marks, product marks, monograms, word marks, abstract logos. So all of them for the legal system is one, right? It is either a visual or a name. And if it's the word mark, which is the name, then it has alphabets which you're protecting, not the way you're writing it. And if it is written in a certain way, like the Coca-Cola with the red background, then it's the logo Coca-Cola written in that particular font with the red background, the same way it is protected, and not the alphabets Coca-Cola if it's not separately as a word mark unified. So this is important to understand the distinction between these two, because people sometimes file just one and they think that they are protected. I have protected my logo, but somebody just uses the same name in a different look and feel, and then they think that they are protected, which is not true. Okay. Let us come to the process further. So where are we? Sorry. Yeah. So now we have registered the company. We have some brand name there, some company name there. We have the idea, which we have already filed as a professional application. And now we have to focus on the innovation and IP strategy. And I'll touch this particular topic later, because there's more detail in that. A strategy basically is for the company. So you now get into product design. So again, when you have done a design, so it's a look and feel design, and you file for a design patent. So Tarun, can you please elaborate a little bit on just the design patent and why we should check infringement, and what we should do in that case, and what is protected if you have a design patent versus a utility patent?
So a lot of people get confused between what, some people say, I want to get a design patent, but then, what they give us is a description of an invention that they've done. So typically, I think it's easier to understand it by saying that I want to file a utility patent, which is like a regular patent for the protection of the functionality of a product that you've made, which will protect the functionality, the technical aspects of that. And then there is an industrial design, which is what Sandy wants to show in point number 9 here. Now, industrial design will only protect the shape of an article. That's it. Only the shape. So if your product is perhaps not very new as regards the functionality is concerned that it does, but it has a good form factor or a fantastic aesthetic appeal to it, then you can file for a design application essentially for this. And for which you just have to get the photographs, give the photographs, and then the application gets filed, and it takes about 6 to 8 months to get the registration through. And what you get the protection for is just the shape. So if tomorrow somebody makes or implements the same product functionality with a different form factor, you'll not be able to stop him. But a lot of cases, iPhone, for example, had a big design litigation with Samsung. I'm sure all of you heard about it, and such products that you can see. You have that sugar-free bottle, which Bipasha Basu used to give an ad of, which was curved from inside. Fantastic product, which was, very unique at that moment. And therefore, and tons of companies get design products registered for the containers that they have, for the lids that they have. Any good customer product should go hand. And it's not that you can only file either of the two. You can slowly get the functionality protected through a utility patent, and then can get the design, the shape protected to an aesthetic appearance.
Exactly. So what you're seeing at present, this is for one of our customers. It's a laser therapy device. So the form is unique. It's a very ergonomic form, and it has two heads where both the heads are functional. So we have a utility patent filed for it, which is not granted yet. But this is the form factor. So we've also filed a design patent, and that is granted. So Tarun, just for everybody's understanding, because this is again something that people understand less, can you please take us through all these things that you see on the first sheet? It's extremely important for people to understand. People think this is all jargon. They don't understand what this all means.
So first of all, this is a US design patent, as they've called it above in point number 12. I will just go from top and then refer to the numbers, the referral numbers that are mentioned therein. Then on number 10 is the design patent number. Like you have regular patent number will be US 901028, but design will have D prefixed to the number. Date of patent is the date on which it got granted. If you come down, number 54 is the title of the design. 71 are the applicants. Applicants and inventors are two different entities. So US is a little complicated. I don't want to go into it at this moment. But typically there are inventors and there are applicants. In the US, there are assignees. So that's a third category that gets done. But in India, for example, there are inventors who are the people who invented it. As applicants are the ones who own it. And in, for example, Microsoft has filed a patent application. There are 3 inventors from Hyderabad. And then there is one applicant, which is Microsoft itself. So that is how applicants and inventors are defined. The US is different because in the US, all the inventors are applicants. And then if they want to assign the rights, they become the assignee. Assignee is the entity to whom you assign the rights. So it's a little different. India doesn't have an assignee concept, but essentially 71, 72, and 73 talk about that. Then there is a term of 15 years from the date of filing. Like patents are for 20 years, designs are for 15. Then there is an application number 21. Application number is the number that you get once you file for a design, and then you get that particular number, and which gets prosecuted, examined, and then after that you get the number 10, which is the patent number. And then there is the filing date of 2016, and date of patent above, as you say, it took probably about 4 years for this design to get through. And then we were taking this application priority from India. So number 30 indicates that we first filed it in India on 11th of June 2016, and then we took that application as the base application, as the mother, parent, father, whatever you may call it, application, and then you filed it in the US within 6 months. And then there are classifications because it's a medical device, diagnostic device and stuff. And then there are different classifications in which the examiner did the search to assess the novelty of this particular device. And 56 are all different documents that the examiner came across, and in view of which he granted the design registration. And then there is the name of the examiner, the attorney firm's name. The claim is nothing in the design. It's just that I'm claiming the shape of an article. And then there's a description. I have 7 figures, front view, rear view, bottom view, and so on and so forth. So that's it.
Okay, brilliant. So Tarun, the important thing here is the distinction between an applicant and an inventor. So I'll give you an example. When I was working with GE, so I have a granted patent for an ECG product, the smallest ECG in the world. Now that patent was granted to GE, and I was the inventor, but I don't have any commercial rights because I have signed a contract with GE stating that everything that I am doing is actually, I share all the rights with GE. So I don't have any control on that. So can you expand on that, that in case, let's say you are 3 partners in a company and all 3 are inventors and also applicants, what are the rights of these individually 3? Let's say they don't continue the company together, but they have a granted patent. So what are the rights of these 3 individuals in that case? We understand that if it's inventors and if they've already assigned the rights to the applicants as a part of the company where they have employee arrangements, that's a separate story. But how do you handle 3 applicants, all 3 granted patent, and now they're not working anymore? Who has what rights? What can they do?
They have equal rights. So there's no dispute around it. If there are 3 applicants and there is no agreement between them as to one of them having, say, 60% and the other 2 having 20-20 each, by default, everything is half, 1/3. In that particular case, if there are 2, then it's half. It's as clear as that. And then the half that one guy has or the 1/3 that the one applicant has can always be assigned to another company. So for example, at this moment also, we are filing some assignments for a company where there were 2 applicants. There were 2 company applicants in the wind turbine space. and one of them wants to assign their half rights to another third company. So that is being done essentially. So the assignment was from the second company to the third company, and eventually there'll be two applicants again, first and the third one.
So does that mean that all the three can manufacture the same product and sell?
I mean, it would again depend on a lot of parameters. Ideally, because all three of them have their own rights, nobody can stop each other from manufacturing an article or even giving a license for that matter. But again, if two of them get together and say that, okay, we have higher rights and we decide to file a suit against the third party for having given a license to somebody else, they can get together and do it. So it's not a very easy answer to give. It's very circumstantial, very dependent on the facts, but typically, because they have equal rights, they can absolutely, all three of them can brand the product differently, unless one of them picks a fight and groups up with the other one and sort of gets into a legal challenge on that matter.
Okay, great. So fine, we have filed the utility patent, we have filed the design patent, we've done the detailed engineering, and we are checking for any infringements if while engineering we are following a process or using the technology that we cannot use. And then we come to prototyping. So at prototyping stage, we have three different types of prototypes that we make. We make physical products as prototypes, we make digital user interface designs as prototypes, and we make then softwares as prototypes. And that's the time when you're actually taking this out, because the prototype is being shown to people. And I think that's the time where ideally you should have filed for an application provisional or final before that. So can you help us understand a little bit about the UI design patents and the software patents? And these are not design patents, these are all utility patents. So can you expand a little bit on the three different areas, the distinction, how easy or difficult it is to get a patent as far as all the three spaces are concerned, if you are unique in all the three cases?
So UI will be very difficult, Sandy, to get a patent on. UI, unless that UI results into some technical effect, into something which improves the efficiency of the computing system as a whole. Like it, for example, reduces the processing time or reduces memory latency or improves some other technical parameter of the computing architecture, it will be very difficult for you to get a patent on a UI per se. In fact, there are many countries, not India per se, but there are many other countries that protect UI as a design, industrial design patent. So if you can really make a very excellent UI, you can take a screenshot of it in a phone and file that as a design application. So that also a lot of countries give. But as far as utility patents are concerned, merely for a good UI, which is fantastically looking, you will not get it. But if it improves the functionality, and same goes for software. So if the software results in some enhancement in the algorithm or machine learning or the manner in which you are creating a neural network or any other technical parameter that you can substantiate that by virtue of this, the amount of memory required for me to store the data and reduces, or the way that I'm encrypting the data makes it more secure. All of those are technical aspects. But you can't really get a patent on a method of booking a ticket from Delhi to Ahmedabad, for example.
Okay, brilliant. So basically technicality is the key. The look and feel all falls in design patent category, which is called design registration in India. And technically, if you have something really inventive, innovative, and which is non-obvious, so it has to be novel and it has to be non-obvious. So Tarun, can you please throw a little bit of light on what is a utility model invention patent, which is there in some countries, because this is something that is confusing,
So China, Japan, China, Germany, and Australia are three countries prominently that have another type of IP. So there is a design which gives you 15 years, the utility patent gives you 20 years. And then this invention patent and utility model gives you about 7 to 8 years of life. It doesn't really get you any protection. I mean, it doesn't go through a substantive examination. So you could, and it's not for software or pharma or any other type of parameter. It is only for industrial products which are tangible in nature, some mechanical engineering patent applications, but they don't get examined and they're provisionally granted. But any third party, when you start enforcing such patents, can challenge the validity of the patent, of that utility model type patent. But I mean, they're very loose patents because, first of all, they're not recognized in a number of countries, particularly say UK or US, which are prominent, even Japan and Korea. But again, if you want a quick patent, very cost effectively, without any examination in say 2 or 3 months, you could really get a patent like that. But again, it comes at a cost of being very low on enforceability.
Okay, great. So guys, I'll just give you two quick examples of what happens if you don't file for a patent or if the patent is not granted. It's important to understand that even if you have filed a patent and it is not granted yet and you launch the product, you still are not safe. You are safe only when you have the patent granted in your name, or you're safe, but you can actually file for infringement and enforce it only once you have the granted patent. So I'll give you an example. This is Polygon Spoon, a very close friend, Rahul, who works with us. He actually designed this particular product, did a Kickstarter campaign for about $1 million. And then the campaign was done in November 2016. And suddenly, after a few months in 2017, you have Orikit, which actually copied the exact same product with slight variation in form and launched the product again on Kickstarter and collected money and also sold decently. Right? So here is, if you can see, picture by picture in the campaign. This was the original Invention images. This was the other campaign. This was the original product. And just by changing the top thing, the curve here, the straight line to a curve here, they could actually do the campaign and assimilate a lot of money in the crowdfunding thing. And you can look at both these Kickstarter campaigns to understand this. So you look at this, so the whole campaign was copied, the product was copied. And at this point of time, which is just after their campaign, I took Tarun's help and we had actually written to both Kickstarter and the Orikit owners, and they didn't bother to respond. And why there was no response? Because we don't have a granted patent till then. Now we have a patent filed. The patent was filed in the US much before, but it was not granted. But it granted in 2019. So now that Rahul has the granted patent, Tarun can actually enforce and ensure that Orikit or any other company cannot manufacture that product and sell that in the US. So the Tarun here, I also wanted to mention that this particular product, the patent was filed after the campaign was done. So guys, please understand, only in the US that's possible that you showcase the product. It is in public domain and you can still file the product patent up to 11 months from that disclosure, unless anybody else has filed it. And in all other countries, that's not acceptable. So in India, if you show it to somebody, it is important that you file the patent before. So that's like one patent. So I also wanted to share what is a good long-term IP strategy. And that's something that we were discussing before. So Tarun, as he said, 2, 3, 5 lakhs can be spent and the whole space can be understood as to what all products are there in that space, or the peripheral products, technologies that are close to that, but not exactly that. So we filed a patent for a cooking apparatus in I think 2010 sometime, and which got granted in the US and UK sometime in 2016-17. That's the amount of time that it can take if you are not in a priority queue. It can take 6 years, 7 years, 5 years, and so on. So what you see here is a long-term intellectual property strategy. So a patent that is filed in 2010, if it gets granted to us in 2017, we have protection only till 2030, and it's already 2021. So which means that I have another 10 years to go before this patent expires, and we need to build a business before that and make it big in the countries that you already have the patent granted. So there are two things. One, patent granted only in US, UK, and India. I think it is still pending. And so which means out of 200 countries, the remaining 197 countries, you don't have the patent. So if the Chinese guys are going to copy the product and sell it in those other countries, they can, because you are protected only in the geographies that you have protected for. And it's expensive. It's expensive to file. It's approximately, as Tarun said yesterday, $3,000 to $5,000 cost of filing and getting a patent granted in any particular country. So if you're filing in 50 countries, you're talking about $150,000, which is more than $1 crore of rupees. So eventually what it means is that you protect yourself in main geography. So US is like 35 to 40% of the world market. UK is another 5, 7, 10%. China is another 10, 15%. European Union is another 10, 15%. So if you cover China, European Union, US, India, depending upon the product category, you're kind of covered in the sense that if the global market is 10 billion, you are covering 6, 7 billion out of that. And that is sufficient to take the 0.5% business that you're planning to build out of that. But the point is that if you are building a sustainable company in the long run, you have to continue working on that, which means that you have to file some CIP applications. After that, you have to file more applications and keep developing the product, improving the product. So a CIP application is continuation in part application, which means that you have improved upon the same idea. It's incremental change. And when you say it's a separate family, then you are talking about a different product altogether. So for example, if the initial product patent was filed something like this, then one patent is now which says that it comes from the chimney. This is the product development from the initial one. And then we are filing how to protect, safety. So safety comes in. So a lot of other technology elements get added into the product. So that becomes a separate patent. And then if you then take it to a prior level where you add a lot of other elements, then that becomes a separate family, of patents. And then you keep improving the idea, you keep adding new ideas and keep filing patents. So if you're Tarun, can you please throw some light on companies like Microsoft and Dell and HP, and what is the number of patents that they have, and what kind of CIP strategies and other family strategies they have?
I mean, every company has their own strategy. Apple, for example, doesn't file as many. Google is very heavy. Microsoft's very heavy. Huawei, we file patents for Huawei in India, and Huawei files tons of applications. I think 16,000 applications a year, something of that nature.
Yep.
I mean, I'm talking about every application being in every country. So that matters. Even if they're filing 3,000 applications in 5 countries each, it is 15,000 applications a year. So, and then each of those applications, they may have multiple claims that they've written for different inventions in a given application. So they keep dividing those applications. They keep filing continuation applications to get broader claims granted. And then they again have the same strategy of continuation and part, where they keep making improvements and file improvement patents, all of which are legally related to each other and hence are all a continuation of the first application. So sometimes you will even see a 2010 application which has 10 applications associated to it, and as long as 20 years, but then there are multiple improvements that happened and they continue to file CIPs there.
Brilliant. So guys, you can search these big companies. There are companies who have more than 100,000 patents filed, and there are companies who have more than 400,000 patents filed. If you look at the big companies, you'll understand. The whole point is that we are a part of the developing world. It's very important for us to understand that design registration, patenting, and then having a continuous strategy to protect all what you have in your company is extremely important. And all the successful companies in the world who are a part of the first world are actually heavily banking on their inventive steps and the strategies to protect their inventive steps by filing patents. They protect them in their own geographies, and they also try and protect them in other geographies like ours, because they eventually may end up, manufacturing the product and selling it in countries like India and China as well. Tarun, can you help me summarize this whole thing? That if somebody wants to come to you and look at a strategy or get some of the work done, what is the process, and what are the things that he should take care of, and so on?
So, I mean, everything starts off with an NDA. That is how we started the session as well. And we understand the business process. We understand what he's intending to do. And then we have a couple of calls with him to understand what could be a right IP strategy. For some companies, patents don't make sense. They're more service oriented. So for them, how strong their contracts are, how strong their agreements are with their clients and vendors and so on are far more important. How they manage their data. If they're an e-commerce company, then obviously, what their terms of service are, terms of use, privacy policy, agreements once again. But for companies that are tech heavy and R&D heavy, obviously we have to look at the product, and if it qualifies both design and a patent, then we sort of keep filing, they keep making improvements. So we then decide whether to file improvement patents or file separate applications, and then which countries to file it in, where to file it in. If it makes sense to file first in the US, then we have to take a foreign filing license and then use that license essentially to file directly in the US first, because filing in India doesn't make sense if strategically it doesn't make sense for them. So I think once you understand the business and the objectives that the clients essentially have, you devise out a clear strategy of where to file, when to file, how to file, at what time intervals to file, and then how to enforce. So you have to be on the lookout for any misuse that might be happening, file oppositions against different companies, third-party observations. There's a ton of stuff, very hard to sort of summarize in a few minutes, but there's a lot of stuff that sort of goes behind a good IP strategy.
Okay, great. So Tarun, I have a few questions. We've finished 1 hour. We have, I think, 30 more minutes, and we'll just address the questions that people have. So guys, I have a request to all of you. If you have any questions, we have summarized a lot of it. There's a lot more information that we can share. So if you have any specific questions, please come up. And to start with, I have some questions that I would ask. So one question, which is a very pertinent question, is that in every university now you have these design schools and these students are making their portfolios and they all come up with these innovative ideas. And since they are less aware and also it's a cost. So what should they do? They have a portfolio, they have some interesting ideas. Should they be filing patents for those, or should they think, how do they, if they have to create a business out of it, is there an easier way, simpler way of doing it, or you know, what do you recommend to students?
If I was to make a recommendation, and if I was probably wise enough when I was in my early 20s to understand the nuances of how IP works, what I would have done is to file a provisional application. It doesn't cost you much. And in fact, honestly, if you read 10, 15, 20, 30, 40 applications on Google Patents, you can even really write a good application. Not a good complete application, but a provisional, which doesn't have the claims. At least you'll be able to get to that and communicate what the invention is all about. Once you've filed a provisional, which for an individual inventor only costs 1,600 rupees to file, less than what a pizza would essentially cost you essentially these days. So once you file a provisional, you go to the market then and there. You prepare an excellent presentation like Sandy does, and not use him because he's very expensive, but otherwise you prepare a good presentation and you reach out to the companies. I think that's the only way. You have 12 months to file a complete. For an individual person who may not have the finances to do self-commercialization, that is manufacturing and marketing on his own, licensing and selling the IP is the next best step. And for that to be done, a good presentation of 5, 10, 15, 20 slides, not showing how big the concept is, but how good the invention is and how applicable could it be for that company. I think you have good 12 months to do it. And if it doesn't work out, ignore the patent. Because then there's no point going forward with an idea that you could not sell in 12 months. 12 months is a heavy time. You can take a week to prepare a presentation and then you have good 10 months to send it. You can meet people. You can, LinkedIn is a fantastic tool. So if something has to click, I think 10 months is good enough. I'm not saying it will license out in 10 months or sell, but you'll get some traction and some feedback on whether you're on the right track and the invention is relevant at all in the first place or not.
Brilliant. So Tarun, that brings to the point relevance. So can you elaborate a little bit on the inventive step and the non-obviousness and the utility of the product asset? Because that's extremely important for people to understand, because everybody has a funnel of ideas. I mean, students have 20 ideas. Which one they should take forward? What do you think is a good way to discuss that and decide that?
So that I think has to be done based on, again, preliminary reviews and searches that they do on Google Patents. I think it's a good tool. It's a very convenient tool to use because we all use Google all the time. So you go to Google Patents and then fill in some keywords. Like, for example, a mechanical spoon or some kind of a spoon that will enable flexible spoon, something that we were talking about Rahul's invention. So those keywords would sort of come to your mind. And then you do your searches, you understand what is out there. And if a lot of it is out there, and there are only very minor points of novelty that you have, then there's no point, because then the protection will also be on very limited notes and it will not have much of a dent. Then you move on to the next idea. I'm assuming that you have a lot of ideas in that sense. But otherwise, if you have a good core idea, then and if you know that that's the one that you want to focus on, then you have to identify as many novel concepts that you can from the searches that you've done. If you can afford a patent attorney, and then obviously you should get a professional help. But otherwise, I think if somebody is serious and concerted, he can do a lot of stuff by himself also.
So Tarun, can you please elaborate a little bit also on the licensing bit? Because yes, I have made the presentation. I found somebody on LinkedIn. I have said, hello, hi, I have an interesting idea, but now I don't know what to do. So can you elaborate a little bit on what do you actually get in licensing? How easy or difficult is that? And then,
in fact, the easiest way for all of these things is to go to YouTube or Google and understand. Again, if you put the same question, Sandy, on Google, you'll get a lot of information. And I'm just going to reiterate it here. But essentially, any licensing deal has two components. There's an upfront that you essentially get, and then there's a royalty. Royalty is always in most cases between 2 to 5%, again, depending on where in the value chain are you. And these are so fundamental now that, you can't even demand 10% royalty unless it's a fantastic product, nobody has made it, and you are at the top of the value chain, and nobody can live without you. Then is when you can perhaps command, because any profitability is around 30-35% in most cases, and 10% is a massive deal out of it, for any company to share. So upfront again can be as low as 5,000 rupees, and they could say that, okay, we'll give you 5% of whatever we sell, and then this is a non-exclusive license, and it could be an exclusive license where they could give you $50,000 also. So again, you have to be realistic. You are a student. You have a concept which you're not in a bargaining power. So I mean, for you to say, okay, I need 50 lakh rupees, bullshit. Nobody will give it to you. So you have to be very, very realistic, which is the reason why I said that when you make a presentation, don't talk about numbers. Don't say that it's $1 billion invention, and because nobody gives any credibility to that at all. It disturbs the whole equilibrium. What you have done, explain that, and then be reasonable that, I've invested so much of time and energy, even if you give me 5 lakh rupees and then you give me royalty associated, that's a practical proposition to make, and the other party will not think that you're crazy.
Right. So to summarize, 2 to 5% is something that you should expect. And this 2 to 5% is the
net sales of the net sales.
But of the net sales, of the manufacturer who's manufacturing it. So it's maybe not Walmart, but if somebody is selling it to Walmart. Yeah. So if a product is sold at $4 in Walmart, the manufacturer is selling it at $2. And then we are talking about this 3 to 5% of that $2 and not the $4.
Unless you get Walmart as your licensee and you sell it directly to Walmart.
Of course. So essentially, yeah, we need to keep in mind that it's the manufacturer who's taking your license and not the final retailer. Yeah. So there's another interesting question. If I get a patent in India and I commercialize it here, can I commercialize it in the US if I don't have a patent there? So Tarun, I would request you to here take us through starting from the initial provisional date, the date of filing for the final application, then how many months I have to file in all of the countries and I can keep selling and so on, so that this answer is addressed, because this is a very pertinent question.
So 2 ways to go and protect yourself internationally. I'm assuming that we are all Indian entities here and we start with India. Be it a provisional or a complete, agnostic of that, you get 12 months to decide whether you want to file or one of the 2 routes. One, you can file an international application called a PCT application, which will again give you 30 months from the priority date. Priority date is the earliest filing date in India, whether you filed a provisional or a complete. So you file an application in India on 15th of January 2020. You get 12 months, which is 15th of January 2021, to file the PCT application. Or and then, if you file the PCT, then you get 30 months from the 2020 date, priority date, to file it in US, China, Japan, Korea, whichever country that you wish to file it in. That's one route of going, which is the PCT route. The other route is the Paris Convention route, where you decide which countries to file it directly within 12 months. So instead of filing a PCT, you say, okay, I'm only interested in the US. Why should I expend money and time and effort to wait till 30 months? I have the resources. Let's then go ahead and file directly in the US only, or directly in China and US, or China, US, and Germany, for example. So these are the 2 ways by means of which you can go internationally. But one more point that Sandy had asked earlier, that if I have a patent in the US, can I sell it directly in, if I have a patent in India, can I sell it in the US? No, you can't directly, because there could be a possibility that there could be a broader patent sitting in the US on the same concept. Now, if, for example, you've got a patent on A plus B plus C plus D, there could be somebody in the US who has a patent on A plus B plus C. And because of him having a broader patent than you, if you launch your product there, you're going to infringe on his patent. Same could be the case in India also, which means that you having, it is irrespective of whether or not you have a patent, whether or not your product infringes on somebody else's patent is a completely different and non-overlapping question. You cannot say that I cannot infringe on somebody else's patent because I have a patent of my own. It is a very, very big misnomer, because a lot of companies file patent and launch their product thinking that nobody will then file a suit against them. It's not the case, exactly for the same reason that if somebody has in India a patent on A plus B plus C, and you filed it for A plus B plus C plus D, D is the novel element on, and because of which you are going to get a patent. So you will get a patent, but at the end of the day, when you commercialize your product with ABCD, you are still going to read on the patent of the earlier guy who has ABC. So having a patent has nothing at all to do with infringement. Both of them are completely different questions.
Right. So that brings up, you can see on the screen, Tarun, I can just quickly take people through. So essentially the applicant can, once he gets into any inventive idea, he can look at the type of the application. So he can file a design patent or a utility patent. Once the patent is filed, then you have to define whether you're filing it locally or globally. So let's say you're just making a small temple kind of a product, which is foldable that goes into your suitcase. It may be apt to file that in India or maybe Asian countries where people carry their murtis and photographs and so on. And maybe you don't need to file that in US. But if it's a new type of a battery charger, you may want to file it in the US and all other countries. And as I said earlier, in the US is like 35–40% of the market. So US, European Union, UK, India, China is our key strategy. Generally, and if you are still hard pressed for money, you can just be US and India. Of course, India, you have to file because you are an Indian. So first application will go in India. And then you can see this whole process, and I will share this particular chart also along with the documents that we would share with the recording. But Tarun, I brought this up because there is another important thing. Can you elaborate a little bit on once a patent is being examined, what happens? So there is a 2 years waiting period, 3 years waiting period, and now an examiner sees your patent. So what does he do? And then what happens between you and him before the actual patent gets granted?
So examiners are typically there to check whether the patent application meets all the statutory requirements. There could be formalistic requirements in the manner in which you've written the application, the claims, and various other sections of a patent application. And there could be, prior art centric objections, which are that your patent application has to be considered novel and inventive and having utility. Having utility is not that big a criteria, but you have to establish the fact that your invention is new and novel in view of anything that got published before the date of my filing. And also, it's not only new, but it's also non-obvious. So it should not be that the examiner alleges that you've made ABCD, A and B was existing in document number D1, C and D was there in document D2, you've merely combined the two, and therefore you arrived at ABCD. And then you have to say that, no, it's not a simple or a mere combination like that. First of all, because document D1 doesn't talk about A plus B, for example, if you can contest like that, or document D2 doesn't talk about C plus D, or even if they talk, then combining these two documents is not obvious. Somebody trying to solve a problem and having the solution of ABCD could have never combined the document D1 and D2 because maybe he had access to D1, but he would have never been tempted to get an access to document number D2 because of so on and so forth reasons. Maybe
yes, so I can just give you an example for that. So we had a company who had come to us and they were designing a new product, which was novel, but it was obviously the next step. How it was obviously the next step? They said that we are using the Type-C connector. This 5 years back when Type-C connector was new. They said, look, everybody else just has normal micro USB. I am using Type-C connector in a particular configuration, and this then attaches to the product in a certain way. So I should get a patent for that. So though it is novel, there is no product that uses Type-C connector in that particular fashion, but it is obvious to a person that, yeah, Type-C is becoming common. Every system is moving to Type-C. So yes, products would logically move to that level. So a normal person with normal understanding of that particular space, if can obviously say that this is the logical next step, then it comes under the category of obviousness. And Tarun, can you also talk about the infringement, not the infringement, basically the prior art examples that are given and how we, rephrase the claims to get the patent? And basically, when you are saying you make the patent tighter and you add more claims into it, can you explain that whole process, a broad patent and a tight patent, and what do we do to eventually get the patent, and how easy it is to, by making the claims tighter, still get the patent if you have novelty?
So I'm a big believer of two types of granted patents. One is just a patent and the other is a good patent. A good patent is a broad patent which has as less number of elements in the independent claim as possible. You know, it will take a whole new session and topic to talk about what claims are and how they are drafted and stuff like that. But essentially, the point is that if, for example, this is the mouse that I'm using, it's a wireless mouse which has certain attributes to it. And if I, for example, while writing it, I talk about the electrical, the PCB configuration of it, the fact that it has some friction elements here and stuff like that. When I talk about these things, the more I talk about these things, the more narrower I'm making the claim. Because then it becomes very easy for somebody to say, okay, I've exactly copied the same, but I don't have your friction elements, for example. Or I'm not using Bluetooth, for example, as the wireless connecting means. Or I'm a wired person, I'm not even a wireless guy, whatever. Or if you, for example, written that my mouse is white in color, for example, you know, so these are limitations. Everything that you add in a claim are narrowing the scope, because tomorrow when you have to prove that he's infringing, you will have to show that his product has each and every stuff, every single thing of your claim, independent claim, has to be there in that particular product for him to infringe on the patent that you've got. So the larger the claim, the longer the claim, the narrower it is, because then there are multiple elements to it. So that's just a patent. You've got a namesake patent, but is it enforceable? No, because you know it'll be very easy for somebody to design around it and say that, okay, I'm not using these three things, and alternatively I'm using this.
So guys, really what is important to understand is that a lot of patent attorneys will file a patent and will get you the patent granted. Just the patent is granted does not mean that you have a great patent and a great product that you can protect forever. A good patent is something which needs a lot of due diligence in terms of, first of all, writing the initial background and the summary and going through a lot of prior art before you actually frame your claims. And then the final claims need to be as broad as possible to ensure that you don't have many other people who can come up with alternate products. So when Tarun is saying the large claim 1, it means that there are 15 things in the claim. So which means somebody else can just change 14th and 15th thing and make another product. Tarun, we have a few other interesting questions and we have about 10-12 minutes to go. So the first question is, do we have an official IP portal where we can check and eliminate ideas?
Every country, so there's no official portal for evaluating ideas or checking it. You have to do a patentability search, for which there are databases like Google Patents and USPTO, which is the United States Patent and Trademark Office. You can also search on European Patent Office, which is a very large consortium of patents, and they cover Japanese and Korean references also. And so those are the databases that you essentially would end up using for doing the searching. But Indian Patent Office, you can also go to ipindia.nic.in. And then there you can also search for Indian patents.
Yeah, and I will share the links. I will share most of the links that you may need at the end of the day with the. So Tarun, if an application is rejected, can another inventor use the model and develop on it and then subsequently get an approved patent? So
he may. So let us assume that there was an application filed for ABC and got refused. And somebody made an improvement on it and added element number D to it. And if addition of D improved the efficiency of the ABC product, surely he can get a patent for it. There's no question about it. And he can commercialize it because ABC doesn't have a patent any which way. So there's nothing stopping the freedom to use or operate that ABCD aspect.
So even if ABC was obvious, because of the D element, the non-obviousness comes in. And then
could come in, yeah. I mean, if you can prove that, yeah.
Another question is that how does it work when you're talking about a mix of commodities, or let's say a recipe, various elements put together in a certain way, in certain proportions. So a little bit about chemical, pharmaceutical patents or molecule patents. Can you elaborate that space a little bit?
So you can have, I mean, there are tons of composition patents all around. In fact, we represent entities like Dabur and many others who have who combine natural ingredients and demonstrate efficacy of the product. So you have to demonstrate efficacy, first of all, that it works for diabetes or for this or for whatever indication. You can't have a recipe of making butter chicken, for example, patented. That is not possible because it is not going to lead to any technical improvement in the manner of, it may improve the taste of it, but it will not increase some technical problem. It may have any other impact, but not technical. So you have to demonstrate that your invention has a technical character to it, and therefore any other composition that has a therapeutic impact, this is your, soothes you out and you can prove it medically and therapeutically and clinically, get a patent. There's no issue there.
Brilliant. And there's another question about the WO. What does that mean? Worldwide application in this whole context, what does it mean?
So WO also means the WIPO is also referred to as, when you file a PCT, you also get a WO number, which is the WIPO office number. But there's no worldwide patent. Everybody knows about it. You have to go country by country. PCT is only a facilitating authority. So you file in India, you file a PCT in 12 months, but you eventually have to file it in the desired set of countries in 30 months. It's as simple as that. You can't really expect to obtain. PCT is not a granting authority, or WIPO is not a patent granting. They will give you a search report, which will be just an opinion on whether or not your concept seems to be patentable to the guy who does a search, but it's not binding. It's just an opinion that comes as part of the PCT application filing process.
Right. So just to elaborate, when you have filed in your country, if you're planning to file only in your country, you don't need to file the PCT application. And at some point of time, because of this problem that every country was filing their own applications, the whole world came together. And I think in 1957, there was a PCT treaty signed in France, where I think about 157 countries came together and said, look, everybody has to file within a year an application with us. We are the WO. And that just means that now you intend to file in other countries later. That is just an intention. Right. After that, to protect yourself in every country, as Tarun said, you have to file in every country. And from a cost perspective, it will cost you anywhere between $3,000 to $5,000, all inclusive, by the time you get the patent, with considering 2 or 3 examinations, talking to the examiner, and so on by the end of it. We have another question. If my projects are posted on Behance, is there a chance to get patent for those products?
If Behance is a platform that allows...
Yeah, it's a platform. It's a platform on which you... If
it takes you public, then obviously no, because if your concept is in the public domain and you file it after it went to public domain, you can't get a patent on that. You can get it in the US, because you get 12 months of relaxation period, grace period, whatever you may call it in the US. But again, the laws are fairly stickle there in that sense. But India for sure only gives you that grace period in case you've given a presentation in front of a learned audience. So if you go to an IEEE conference in India and then you make a presentation or publish a paper, and then you file, then you get 12 months to file a patent application, that's okay, because the disclosure was made in front of a learned audience. But if it's a public disclosure on a platform which is public in totality, nothing in India, most other countries.
Brilliant. So, we have just 5 minutes to go. To conclude, I'm just sharing the initial slide once again for everybody to get an overall overview. So guys who joined late, this is the overall process for design, right from beginning to the launch of the product. You file for a provisional patent in the beginning. When you have the idea, you incorporate your company. So whatever you need to do for that, you do that. Then you do IP research, and Tarun can help in that, or any other IP attorney can help in that. This IP research will ensure that your provisional patent that you are planning to file or you've already filed is actually something that makes sense, and you're not just wasting your time for the next 6 months because the idea that you have already exists in many different ways. You can also do patent landscaping, which is a much bigger space, trying to understand the whole thing, and that may cost 2 to 5 lakh rupees. When you're getting into product design, you may come up with an interesting form and you need to check infringement if while developing the product, you have to go back again and look at the patents, whether you're doing it right or not, and everything that you're doing is protectable or not infringing somebody else. Again, while engineering, prototyping, you have to check for infringement. When you're doing prototyping, tooling, and manufacturing, you have to have your NDAs in place with all the people with whom you're working, because you've already started to share outside your own office or company, whatever you're doing. You may also sign contracts that keep people legally bound. NDA on a stamp paper is better, with all the details signed on every page. Ensuring that the clauses are there that talk of that it's only in the email, and all the confidential information is named as confidential is important. Then as far as along with this whole product development, you're also doing your communication design. So your logo, trademark, wordmark, if your product name and your company name are going to be the same, it's better that you apply for them together. And Tarun, can you elaborate a little bit on the Madrid thing, that within 6 months you can apply for the rest of the world as far as the logo and trademarks are concerned? We discussed the utility patents, but not the logos. How do we go international with the whole logo bit?
Both designs as well as trademarks follow the same principle that you can take priority. So if you file an application in India, you can take the priority of that Indian application and file a Madrid application for trademarks, for example. So if you file a trademark for XYZ and then you get 6 months, if you file a Madrid-based trademark application, you can select the countries. Say I want to go to China, Japan, US, and Canada. And then the Madrid platform will automatically file your applications in all these chosen sort of 4 countries.
Brilliant.
And then there is an objection that comes from because of similarity of mark or any other reason that there's an objection that comes. Then you will have to engage a local lawyer there too, or the Indian attorney that you engage. He will help you out and working with one of his associates.
So the important thing here is that if you file the Madrid application, you can just pay the fees for different countries, and the lawyer's fees are saved. So then whatever is the government fees, that's what you pay. So from there, then you move to the UI UX. So UI UX, as Tarun said, if it's just the user interface, the screens you can file for a design patent for them, but they're not very protective. Anything that is the software or any utility that you enhance or anything that is technical that takes the world to the next level is a utility patent. So for the software, for the UI UX, you can file for a patent and get granted, and that will protect you. For product packaging, for photography rendering, you can do the design registration, or anyway, you get the copyright once you do your photographs or renderings as you publish them in your name and so on. Same for animations and so on. And again, before you launch your product in the market, you ensure that you are registering the brand in geographies where you are launching the product, and take care of all these steps that are there in your screen. So this is Sandy once again. My name is Sanandan Sudhir. I can help you with the whole process of product development from beginning to the end, including the communication design part. And that's Tarun Khurana. He can help you with all these red dots that are there in the whole process. Thank you very much, guys. I think I've addressed all the questions. Oh, there's one more new question.
Sanandan, I think if you could share the email ID, so if anyone has questions, they could write to you or Tarun.
Yes, so my email ID is sandy@inventindia.com, sandy@inventindia.com. Tarun, can you please just speak out yours?
Tarun@Khurana and Khurana.com.
Okay, great. So there's another question on throwing some light on publications, book publications. So Tarun, I think that is copyrighted anyways as soon as it is published, right? But yeah. Is there anything?
Copyrights are inherently protected on the date of creation itself, but you can also file for an explicit registration, because that becomes a prima facie proof. If somebody else copies it, then you can easily prove that you have a registration for it. But otherwise, copyrights are implicitly protected on the date of creation automatically as well.
Great. So thank you very much, guys. Over to Gauri for the final vote of thanks. Gauri, please go ahead. I'm just stopping the screen, the share screen.
Thank you both for a very enlightening session. It has been wonderful to have this session finally take place under the umbrella of ADI Ahmedabad. It was long due, and we're very happy that Tarun agreed on such short notice to this with us. I think very, very valuable for a lot of the younger generation that's coming up. And for those who are attending and not ADI members, I would request you to join in. There are various forms in which you can be part of the ADI. Anywhere. ADI is a countrywide organization, so please join us, and you can be part of any chapter that you kind of are. Let's say if you live in Ahmedabad and you become an ADI Ahmedabad member, but if you shift to Pune, you can take your membership to Pune as well. So it's not limited to a city. You can find all the information about ADI, of course, on the website, and also the membership methods. So thank you very much, and let's do this and more of this again and again, and make the community thrive, do more. My biggest concern always has been that from India, we file way too few patents globally, and we need to have products that are marked with Made in India more and more. Thank you so much.
Thank you, Gauri. Thank you, Tarun. Thanks a lot, guys. Have a great day and a weekend. Bye-bye.
Bye-bye.